Hi guys, welcome to session 3 of the Law of Tort. By the end of today's session, I hope you're able to understand and apply the following elements of the tort of negligence. We're going to look at breach of duty of care, causation, and harm or injury. So just a quick review on what we've done so far. During session 1, we created a mind map, which you can see on the left side here, or at least half of the mind map. We looked at obviously the requirements to being able to deliver this assignment on time and to a good standard. So we initially looked at the assessment, it being an academic essay. We then looked at what we might write in the first paragraph, obviously the meaning and development of tort. And of course, because we are business students, it was important to apply business here and for us to understand why the law of tort is such an important factor in running a business or even being a consumer as well. And how your rights as a consumer can be affected by the law of tort. We then started to look at the elements of the law of tort. In particular, we focused on duty of care. And so today's session is about covering the remaining elements of breach of duty, causation, and harm or injury. Now, before we move on to that, it's good to just review and remind ourselves of duty of care, because that was a key element. In particular, we looked at the 3 stages that need to be established to determine whether there is a duty of care. Number 1 being, is there a relationship of proximity between the parties? Number 2, was the injury to the claimant foreseeable? And number 3, is it fair, just and reasonable to impose a duty? So we looked at the case of Donahue versus Stevenson, and we was able to apply the 3-stage test there. So we've been able to look at some previous case law already and see how that 3-stage test works. So now we want to move on and talk about the breach of duty. So let's take a look now at the second element, breach of duty. As you can see here, it's defined as, for the tort of negligence to have occurred, the defendant must have breached the duty of care legally imposed on them. The reasonable man test is usually applied to ascertain whether the duty of care has been breached. This is an objective test and considered whether the behaviour of defendants fell below the threshold of a reasonable man. So the concept of the reasonable man test originates from a law report in the early 1900s by Lord Bowen. As you can see, it was about trying to define the ordinary average person, and Lord Bowen casually said we must ask ourselves what the man on the Clapham omnibus would think. Just to clarify, omnibus is basically a bus, someone commuting to work out in South London, I think it was Clapham, yeah, and typical commuters, and it was about what is deemed as reasonable behaviour, and reasonable behaviour is kind of associated with ordinary or average people, and that's what this test is about. So it's used to define the typical opinions and behaviours of the average person in order to determine a benchmark of how someone would reasonably act in a given situation. Maybe we can further understand this by looking at less ordinary things or less ordinary situations. So here we have an example of medical negligence following a surgical procedure. The behaviour, i.e. the skills of a specialist surgeon, will be expected to be of much higher standard than the skills of, say, a junior doctor assisting. However, inexperience of itself will not be valid defence. So the defendant is expected to discharge his or her legal duties as reasonably skilled and a competent person. So hopefully that clarifies a bit that there is the reasonable man is looking at the average person, but also if you're a surgeon, you have a certain level of skill, and so therefore what is reasonably expected of that surgeon with their level of skill. That's why it's important to determine whether a surgeon during a medical negligence case has behaved at, at what their standard of skill perceives them to be. Let's take a closer look now at a previous case, Bolam versus Frayne Barnet Hospital Management Committee, 1957. So Mr. Bolam suffered from mental illnesses and was advised to have electroconvulsive therapy, which causes severe muscular spasms. The doctors given the treatment failed to give relaxant drugs or any means of restraint during the treatment. The claimant suffered a fractured pelvis, and the question for the court was whether there was negligence in the practice of providing neither relaxant drugs nor restraint. The court received evidence that a number of doctors carrying out these procedures took different views on use of drugs and restraint. Since there were other doctors who would have carried out the treatment in the same way, without drugs or restraint, the doctor here had acted in accordance with a competent body of medical opinion, and therefore no breach of duty had occurred. So hopefully that helps you understand this idea of the reasonable man test. And as you can see from the note here, where you get a situation which involves the use of some special skills or competence, then the test as to whether there has been negligence is not the test of the man on the top of the Clapham omnibus, but the test of the ordinary skilled man exercising and professing to have that special skill. Another useful case to look at to help explain the three-stage test is Rowe versus the Minister of Health, 1954. So a patient became paralysed after being injected with a spinal anaesthetic. This had been stored in a glass jar, and the glass jar stored in a sterilising fluid called phenol. Evidence at the court case showed that the phenol had entered the anaesthetic through the glass jar, contaminating and leading it to the claimant's paralysis. However, there was no breach of duty. Such an event had not previously occurred, and so was basically unforeseeable. So this points to the stage 2 of the three-stage test, where it says to establish whether was the injury to the claimant foreseeable. So because it was the first time it happened in this case, then it could be argued that it was unforeseeable, and therefore the hospital in this case wasn't held accountable. So another useful case to help us understand the three-stage test is the case of Paris versus Stepney Borough Council. So the claimant, a mechanic, had only one eye. He was then blinded in his good eye from an accident at work, as his employers had failed to provide him with protective goggles, which they were legally required to do. The employers were found liable to him to the extent of causing total blindness, rather than the loss of sight in one eye. The claimant's partial sight meant that the duty towards him was necessarily greater than normal. So looking at the three-stage test, of course, there's a relationship, employee versus employer, so the proximity is clearly there. Was the injury to the claimant foreseeable? Well, yes, of course. I think without wearing protective goggles and in the job as a mechanic, it's quite foreseeable that injury can take place. And is it fair, just and reasonable to impose a duty, especially to this degree, because they're talking about complete loss of sight, blindness? Then it can be seen that under the duty of care, as it says here, there needs to be necessarily greater than normal because of the mechanic having an initial disability of having just one eye, one good eye. So let's take a look at the third element of the law of tort, that's causation. So once a breach of the legal duty of care has been established, it must be shown that the loss, damage or personal injury was caused as a result, whether directly or indirectly. The question is, but for the actions or omissions of the defendant, would the loss or harm have resulted? Now, to further understand this, let's take a look at the case of the Oppressor in 1943. So a ship was negligently navigated, and this caused the damage to another ship. The captain of the other ship decided to approach the Oppressor in a lifeboat to get help. The lifeboat overturned and several crew members were drowned. their relatives sued the owners of the oppressor. The owners were liable as the action of the captain were reasonable, and the heavy seas causing the lifeboat to overturn did not break the chain of causation. So let's examine that further, because it is a little confusing in places. So the oppressor is the ship that was navigated negligently, damaging this other ship. The captain from that other ship decided to jump in a lifeboat with some of his crew and seek help from the oppressor. Now this is seen, remember the reasonable man test, this is seen as quite reasonable behaviour. If your ship is in danger and there is another ship nearby, it's very reasonable for the captain to then order some of the crew to get into the lifeboat in an attempt to reach the other ship. The fact that the seas were choppy, as it says here, heavy seas, did not break the chain of causation, because the captain was deemed to behave reasonably given the situation. So just as a little side point here, if one of the crew had decided to swim to the oppressor and drown, the chain of causation would have been broken and the ship owners would not have been liable. So it's important here the captain made the reasonable decision to take this approach, and therefore the shipping company was held liable. So finally, the fourth element, harm or injury. So there must be some form of loss, damage or injury. This includes physical or mental personal injuries, financial loss or damage to property. It can also extend to emotional distress or embarrassment. Let's just take a look at this case here, because there is a clear loss in regards to the claimant. In this case, it was Barnett versus Chelsea Hospital. The claimant's husband went to hospital, complained of vomiting. He was not examined and told to go and see his doctor. Later in the day, he dies of arsenic poisoning. It was held that defendants owed a duty of care, and the lack of treatment was a breach of duty of care. However, their breach did not cause the death, because it was discovered that even treatment at this stage could not have saved his life. So if we break this down, it was a clear duty of care by the hospital to provide care for this lady's husband, and this didn't happen. However, his resulting death was not the cause of this breach of duty of care. So this is an issue of causation. We mentioned when we looked at that, the third element, because it was believed that, from ingesting arsenic, he would have died anyway, regardless of whether the hospital had intervened at that early stage. So lots of interesting cases there that help us understand the elements of the law of tort. Now, this lesson is designed to hopefully encourage more questions than actually give you answers, because it is a little bit confusing. Hopefully you'll watch this before our session on Wednesday, and we can have a Q&A session and begin to understand it more, and more importantly, how we can apply these elements to our own scenario that will help us complete the assignment for this particular unit. Okay, so I hope to see you all on Wednesday to discuss this further. Bye for now.